The court system in the United States is complex, convoluted, and problematic, but it's not impossible to understand. In fact, the basics are quite simple. In this video, we'll do a quick overview of what the major structures are in the court system, how they work, and how sometimes they can lead to injustice. There are essentially two main parts of the court systems that work in parallel with one another: the federal court system and the state court system. There are also a number of individual court systems dedicated to specialty topics, which we'll get to in a little bit.
The federal courts are granted power from the federal government, while the state courts are granted power from the respective state-level governments. Though each system is different in many ways, they function similarly. Trial courts are where cases are first tried and disputes are resolved by determining the facts of a case or applying the law. Here is where the original verdict of a case is made. Appellate courts are those that hear appeals from the trial court. So, for example, if a party is unhappy with a decision made in a trial court, they can appeal to have it reviewed again in these courts. In the federal system, the trial courts are called district courts. There are 94 of them, with at least one in each state, and they are organized into 11 regional circuits and the District of Columbia. In the state system, the trial courts are called local trial courts, sometimes referred to as district or circuit courts in some states. These can vary greatly by state. Moving on to the appellate courts. In the federal system, you have the Court of Appeals and the U.S. Supreme Court. The Court of Appeals hears cases appealed from the district courts. These cases can be appealed again, which is where they can go to the Supreme Court. The Supreme Court is the final court of review, and it actually hears very few amount of cases. In the state system, you have state appeals courts and the state Supreme Court that function in the same way as the federal system. However, some states can have multiple appeals courts that focus on different types of issues. When a case makes it to a state Supreme Court, it can also be appealed again to be heard in the U.S. Supreme Court on the federal level. All of the cases that go through these two systems are either civil cases or criminal cases. Civil cases are those that are brought forth by an individual or entity against another party that has failed to carry out a legal duty, for example, when somebody sues someone else. Criminal cases are those that are brought forth by the government to accuse an individual of breaking the law.
Some of the people you'll see in the courts both on the state and federal level are the jury or the judge who rule on the case. Judges on the federal level are appointed by the president and confirmed by the Senate and serve lifetime appointments. On the state level, they can be chosen through gubernatorial appointment, elections, selection committees, or a combination of methods. Some facts about federal and state judges are 57% of state trial court judges are white men. 48% of federal judges are white men, only 10% are women of color. So far, 91% of Trump's nominees are white, and 81% are white men. You also have the plaintiff who initiates the lawsuit. This will either be an individual, an entity, or the government. The defendant is the party being accused. In criminal cases, the plaintiff is the government, and the person who introduces legal proceedings is called the prosecutor. These are people that build the cases against the defendant and can provide a plea bargain, which is an agreement whereby the defendant agrees to plead guilty in return for a lesser sentence. Some interesting facts. A 2015 study found that 95% of elected prosecutors are white and only 1% are women of color. About 97% of federal criminal cases and 94% of state cases end in plea bargains. This is because the system encourages people to take plea bargains, even in cases where they're innocent, especially low-income people that cannot afford a lawyer. In criminal cases, if a defendant can't afford a private lawyer, the government will provide them with a public defender. The only problem is that public defenders are more often than not understaffed and underfunded, which leads them to encourage clients to take plea deals. More than 80% of people charged with felonies cannot afford a private lawyer.
And lastly, outside of the federal and state court systems, there are a number of independent court systems in the U.S. You have tribal courts, which are independent to each tribe, Jurisdiction is complex in these courts. One of the biggest problems, however, occurs when tribes are unable to prosecute crimes committed by non-tribal members on native lands. You also have immigration courts, which are overseen by the Department of Justice. These courts oversee immigration cases. However, there is a severe backlog in cases, leaving many folks in the immigration system in limbo for years, and they lack the policies and procedures to ensure a fair trial for many immigrants. And you also have military courts, which are administered by the military's criminal code.
There are many intricacies to the court system in the U.S. that we don't cover here, but don't worry, this is meant to be used as an overview, a refresher, or a starting point as you continue to learn to break down these different structures. But remember, you can use this information so you can reform this system to make sure that it really upholds justice.